416, prohibiting fines and fees from being assessed against a juvenile or a juvenile's parent, guardian, or custodian in a case pursuant to the revised Kansas Juvenile Justice Code. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Reviser of Statutes. You have a fairly substantial bill brief, fairly long bill, and a number of conferees, so I will try to keep it short. As the chair mentioned, the bill would prohibit fines and fees from being assessed against a juvenile or a juvenile's parent, guardian, or custodian in cases involving the revised Kansas Juvenile Justice Code. The new section, Section 1, provides that in an action under the revised Kansas Juvenile Justice Code, no fines, fees, costs, court expenses, reimbursements, or other financial obligations shall be ordered, assessed, or sought against a juvenile or a juvenile's parents, guardian, or custodian. So that's sort of the global prohibition on those fines and fees. After July 1st of this year, which is the effective date of the act, couple things happen. One, any outstanding court-ordered fines or fees owed by a juvenile or their parent, guardian, custodian that were assessed in an action under the code shall be discharged and shall not be collected. So this retroactively wipes out those outstanding fines and fees. Second, any juvenile who's participating in immediate intervention or is on probation or is in a detention facility or correctional facility or being supervised solely because of those outstanding fees or fines shall be discharged. So if that's the only reason you're still on intervention, probation, etc., you'll be discharged. And third, a juvenile, their parent or guardian who's incarcerated solely because of non-payment of fines or fees shall be released from custody. This will not apply to restitution. So there's a specific provision that says it does not apply to restitution that is owed by a juvenile, but otherwise it applies to all fines and fees. The rest of the sections are amendatory. I'll very briefly give you an idea of what's in each one, but I won't go into any detail unless you have questions. Section 2 is the fingerprinting statute. It says no fee will be assessed for fingerprinting. Section 3 is the library fees charged by district court clerks. That will not be imposed. Section 4 is the Secretary of Corrections house arrest program costs and fees. Those will not be imposed. Section 5 is the Offender Registration Act, and the fee that goes along with registration, that will not be charged for a juvenile that's registering only because of a juvenile adjudication. Section 6 is the docket fee provision, and those and the additional $1 charge that's for prosecuting attorneys training fund, and also the non-judicial personnel charge that you're all familiar with that the court imposes. Those costs and charges will not be imposed. Section 7 is the prosecuting attorneys training fund. That fee will not be assessed. Section 8 is the forensic science fee. That fee will not be imposed under the Juvenile Justice Code. Section 9 is the Supreme Court's additional charge to fund non-judicial personnel. That charge will not be imposed under the Juvenile Justice Code. Section 10 then gets into the Juvenile Justice Code itself. So there's a number of sections in the code that have specific fines and fees provisions. So I'll give you a little bit more detail on a couple of these. Section 10 is the one saying that juveniles are entitled to an attorney during proceedings. The expenses of that appointed attorney will not be assessed against the juvenile or their parent or guardian under the bill. Section 11 deals with juvenile adjudication expungements. The amendments provide that no docket fee, charge, or other costs are imposed on a petition for expungement under the code. It's also there's also an amendment that provides the court will not deny or delay processing of a petition for expungement because of unpaid court costs, fees, restitution, etc. But for the purpose of collecting outstanding restitution, certain persons will be given access to the expunged case file. So to facilitate restitution still being collected even after expungement, certain folks will have access to that expunged case file. Section 12, is the statute in the juvenile code that provides for care and custody expenses of the juvenile. There are certain expenses paid out of the county general fund that are then sometimes assessed at the expense of the person who is liable to support the juvenile. So the bill provides that those will no longer be assessed against the juvenile or the person responsible for the juvenile. They'll be borne by the county. Section 13 is the statute in the Joe Code that requires offenders to pay the costs for certain counseling and testing. Those fees and costs will no longer be charged to the juvenile or their parent, guardian, custodian. Section 14 is the one about pleadings under the code. There's a current requirement that you pay, or that the complaint has to contain a request that the parents of the juvenile pay child support in the event the juvenile is removed from the home, and that provision is removed. So there will not be an assessment of, or a pleading of requiring child support. Section 15 deals with detention criteria for juveniles. And there's an amendment in that section that provides no juvenile will be placed in a detention center solely due to non-payment of fines, fees, costs, or restitution. Section 16 is the juvenile code statute requiring the juvenile intake and assessment services directors to adopt policies about immediate intervention programs. The bill strikes a provision that says you cannot be denied participation or terminated because of not paying your fines or fees, and provides that no costs will be imposed on the juvenile or their parent, guardian, custodian for participation in these immediate intervention programs. Section 17 is the statute about incompetency of juvenile offenders. Under current law, one or both parents of the juvenile can be ordered to pay child support under this section, and the bill removes that provision, so that cannot be assessed any longer. Section 18 is related to post-adjudication orders and hearings. There are some costs imposed for mental health evaluations and treatments and certain post-adjudication assessment tools. Those costs will no longer be assessed against the juvenile or their parent, guardian, custodian. Section 19 is the Juvenile Offender Code Sentencing Alternatives Statute. The amendment here provides no financial terms or conditions will be placed on a juvenile or their parent, guardian, custodian for participation in community-based programming, out-of-home placements, house arrest programs, drug or alcohol testing, electronic monitoring, or remote alcohol monitoring. And then Section 20 deals with the statute authorizing orders related to parents under the Juvenile Offender Code. Current law allows the Board of County Commissioners to require parents to pay certain costs for house arrest and to pay child support. The bill removes those provisions, so that will not be applied to parents any longer. Section 21 and 22 are just correcting some cross-references. Those are both Juvenile Offender Code provisions, and there's some cross-references that need to be fixed because of other changes made in the bill. Same thing for sections 24, 25, and 26, and all of those are listed in the bill. Just a cross-reference change, no substantive change. Section 23 is about fees and expenses for appeals. The costs for those appeals are going to be paid from the county general fund, not by the juvenile under the amendments in the bill. Then Section 27, the last one I'll mention, is the DNA testing statute, and that would provide that juveniles will not be assessed any costs for DNA samples that are collected under that provision. With that, I think I covered them all, and I'll be happy to answer any questions.
Thank you. Committee questions? Not seeing any. Thank you. Appreciate that. And then for our conferees, we do have a number of conferees. So I'm going to be asking that each conferee's testimony be limited to 3 minutes. And we'll have a timer up here. So when you hear the timer, please be respectful and wrap up your testimony at that time. And we will then first hear from our first proponent conferee, and Noah Bain from the Justice Action Network. Noah?
Thank you, Chair Warren, Vice Chair Wilburn, Ranking Member Corson, members of the committee. My name is Noah Bain. I'm the State Policy Manager for the Justice Action Network, or JAN. We're an organization that works in states across the country to support lawmakers enacting criminal and youth justice laws that improve lives and protect public safety. I want to just briefly highlight how and why Senate Bill 416 is supported by research and falls within trends set by other states. First, this is neither a liberal nor conservative bill in its goals. It's simply common sense policy supported by organizations like Americans for Prosperity here in Kansas and the American Conservative Union nationally, endorsed by multiple Kansas district attorneys, which you'll see in your written testimony, and already enacted in states like Texas, Arizona, and Louisiana. Last year, the Kansas Joint Committee on Corrections and Juvenile Justice Oversight unanimously recommended ending juvenile justice fines and fees. Then, during that session, a bill mirroring the one before you passed unanimously out of the House Committee on Corrections and Juvenile Justice. To build on that success, in July, Jan worked with Representative Stephen Owens to pass a model policy at the American Legislative Exchange Council's 2023 conference. ALEC's Elimination of Youth Fines and Fees Act is now model policy for the nation. Ending fines and fees for kids is a bipartisan goal that makes sense no matter what your ideological vantage point is. As I mentioned, these fees in youth justice are no longer imposed in Texas, Arizona, Louisiana, and so many other states after lawmakers put an end to the practice in recent years. Second, I want to highlight there is no evidence that imposing fines and fees on kids deters future crime. If you hear testimony to that effect, no, it is not supported by research. In fact, there is some evidence that it can increase the victimization of your constituents, creating new victims through higher recidivism. Third, imposing fines and fees on young people in Kansas is so bureaucratically inefficient that your taxpayers likely lose money in the collection process. Put it this way, if the IRS had the same collection rate as Kansas's efforts to claw back fines and fees from young people whose parents can't afford to pay them, our nation would lose money at the tax deadline year after year after year. Finally, data show that the Kansas juvenile justice system does not need this money to function. It is simply not true that this tiny sum collected pays for youth justice system operations in any real way, nor should it. KDOC reports that youth justice expenditures statewide in 2023 totaled more than $500 million. Any jurisdiction in Kansas can apply to receive funds from the evidence-based programs account, which doled out more than $36 million last year, and in itself is a model for the nation. In contrast, the fiscal for this bill shows that over the last 4 years, the state collected an average of just $617,000 annually. That's just gross revenue, not net the cost of collection, which likely exceed that amount if Kansas is anything like other states that have reviewed this data on the issue. And with that, I thank you for the opportunity to speak, and thank you for taking the time to consider this important issue.
Thank you. Appreciate that. And right at about 3 minutes. So that was well timed. Appreciate that. Next, we will hear from Desmond E. Bryant White, Program Manager, Progeny. Please introduce yourself and welcome to committee. Make sure your microphone's on. There we go. Thank you.
Mic check. Hello, my name is Desmond Bryant White. I am the manager of Progeny, which is a program of destination innovation, a hub of youth enrichment. In Progeny, we believe that we have to reimagine the juvenile justice system, and we work in a youth-adult partnership. So I get to work with young people who face with these challenges every day. We believe every child in the juvenile justice system deserves justice and respect in order to make a safe and thriving community, and we must address the root causes of this harm and work collectively in order to make change. Fines and fees affected my life as I turned 18. However, a lot of those fines and fees still affect my life to this day. Trying to rearrange my financial situation in order to make payments, reevaluating whether I need to pay this fee and keep my freedom or pay a rent bill and keep my family's livelihood at stake. So I can only imagine the stress and the anguish that a young person would face while trying to pay off a fee. As an adult who has been there and back, I think that it is safe to say that this system is not giving our youth a fair chance at a successful future. When we think about the amount of resources that we spend to collect fines and fees versus the amount of money that's spent on resources to impact our youth, it should be embarrassing because we don't give the same energy. When young people and their families are unable to afford these court costs, their cases are kept open longer solely for missed payments, but they also miss school or they can miss work, all in order to go to court for these fee-related court dates. Young people can be faced with heavy loads of debt, civil judgment, and ruined credit, limiting their opportunities for years to come. Children don't pay bills and they can't have jobs. So requiring juveniles to pay fines and fees at every point in the juvenile justice process, we place a burden and a harsh punishment on working families, many of whom already live paycheck to paycheck, trapping them in a cycle of debt. Our young people in the community should not be considered as a funding stream. Resources for our youth should be easily accessible, no matter the financial barrier. Kansas court charges children in the legal system and their families thousands of dollars in unjust fees and fines at every step in the court process. These financial penalties undermine public safety, family stability, it punishes poverty, deepens existing racial and economic disparities, and sets young people up to fail for years to come. Although judges do have discretion to waive these fees, we find that sometimes that this is done in discretion. However, it's not distributed equally to my community. Kansas legislators have the power right now to be responsible to take effect on this immediately and advocate for this bill. I ask that we don't forget about the youth who don't have a voice, that we don't forget about the youth who are underrepresented, that we don't forget about the youth who are marginalized in these communities and who have made a mistake.
That's 3 minutes, sir.
Thank you.
Appreciate your testimony. Thank you for being here. Next, we will hear from Dante Bristow, youth leader intern of Progeny. Please introduce yourself and welcome to committee.
Mic check, mic check. Hello, my name is Dante Bristow. I grew up in the system young. Every step of the courts, they are charging you fines and fees, whether it's probation fines, urine samples, bracelets. Everything is a fine and fee every time you go through this court system or even get into the system. In my system, in my community, I grew up in a poor community, which is the Black community. We tend to not have money. So we tend to have lack of money, so we can't pay for these fines and fees. So we end up getting stuck in a cycle that is continue racking up on us because we can't get ourselves out of that cycle. I couldn't pay these fines and fees when I was young, so I was one of those kids that ended up having to drop out of school because it was either pay these fines and fees or go to jail. So I had to make a decision. I actually was on an ankle monitor. I remember I was 16, I was on an ankle monitor. They put me on an ankle monitor. I couldn't pay for these fines and fees, so they locked me up for me not paying these fines and fees. But then they let me back out on the same ankle monitor that I couldn't pay these fines and fees for. We are hurting the community by charging the youth fines and fees and treating them like they're adults. I actually moved away, got out the cycle. I broke the cycle. But here I am still paying fines and fees for things I did when I was a juvenile. The cycle, this community is hurting us by these fines and fees. I'm nervous. I'm sorry, but that's my testimony.
Thank you. Appreciate it. Thanks for being here. Next, we will hear from Tyler Williams, community organizer with Progeny. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Tyler Williams. I'm one of the original youth leaders with Progeny, and I am a formerly adjudicated youth here in the state of Kansas. My fines and fees testimony begins with my first charge against me, which involved an officer transporting me from Oklahoma City to Junction City, which in total was $840, a very expensive car ride. On top of my additional court costs after sentencing was about $1,000. While I was adjudicated for almost 6 years, any time money sent in from my family, half was taken immediately towards my debt. Once obtaining my first job, half of my check would immediately go for that as well. In total, my total adjudication, I paid $200 towards my debt. Upon my release, there were such things as violent offender registry, probation fees, and costs regularly. I was at a halfway house for 9 months, under the belief that I would be there for at least a year and a half, and was eventually released for completing probation. I had no heads up. My intensive supervision officer just told me they weren't able to get the 3-month extension, so I was released. Upon that notice, I was released out of KDOC custody and became homeless. At that time, collection calls started coming in. I was minimum wage job, no home, no car, and had to take half of my check to pay towards my fines and fees or else face wage garnishment and other punishments. My story is just one example of the financial burdens that are placed on the youth of the juvenile justice system. I was lucky enough to get a strong support system built up under my feet that was able to help me get on my feet. If we really want to help Kansas youth rehabilitate back into society, then we need to help them after making a mistake, not hurt them. We need to stop treating kids like adults because this is insanity. We need to help the youth. Thank you.
Thank you. Appreciate your testimony today. Thanks for being here. Next, we will hear from Mike Fonkert, Deputy Director, Kansas Appleseed Center for Law and Justice. Please introduce yourself and welcome to committee.
Thank you, Chair Warren. My name is Mike Fonkert. I am the Deputy Director at Kansas Appleseed Center for Law and Justice, and I appreciate the opportunity to speak today in support of Senate Bill 416. First, I'd like to just acknowledge that this is a kind of a culmination of multiple years of work by a bipartisan coalition. As you heard some of the speakers mention already, this is supported across the country in conservative, liberal states, and in this state as well. We have a very diverse and broad bipartisan coalition. The revised Kansas Juvenile Justice Code establishes the primary goal for the code includes promoting public safety and improving the ability of youth to live more productively and responsibly in community. The elimination of fines and fees is an effective way for us to accomplish these goals. Research shows that financial penalties actually increase the likelihood of recidivism for our youth. Not only are fines and fees levied against justice-involved youth harmful and counterproductive, but the cost of collecting them often outweighs the revenue they generate. While fines and fees do not raise much revenue for the state, they do impose a significant burden on Kansas families. Fines and fees are imposed on youth at every stage of the process in Kansas, and every stage of their interaction with the system, including courts, defense counsel, docket fees, intervention program fees, etc. These fines and fees can turn into multi-year struggles as they multiply with collection fees over time for those without the means to pay. A recent study found that kids and families who can't pay fines and fees reported not paying essential bills in order to pay their court bills, and low-income families should not face a different system of justice in Kansas. Eliminating fines and fees for justice-involved youth is a real solution that has been supported in this legislature and around the country. Last year, as you heard, a bill to eliminate fines and fees for these youth had bipartisan support and passed out of committee on the House side. 16 states have passed fine and fee elimination bills since 2015, including Louisiana, Texas, Colorado, Montana, and Virginia. So I urge you to listen to the bipartisan support in this state house and to your colleagues in other states as well that have seen the ineffectiveness and counterproductive results of youth fines and fees. And I urge you to support Senate Bill 416. In doing so, you'll be keeping a promise to Kansas kids that a mistake they make as a child will not set them up for a lifetime of failure, but instead will get them the support they need to thrive as adults. Thank you so much for your time.
Thank you. Appreciate that. Thanks for being here. Next, we will hear from Rashane Hamby, American Civil Liberties Union, Kansas. Please introduce yourself and welcome to committee.
Sure. Good morning, Chair Warren, Vice Chair, and members of the committee. As stated, my name is Rashane Hamby, and I'm the Policy Director for the ACLU of Kansas. First, I'd like to thank you all for allowing us to put faces and names to the issues at hand, an issue that deeply impacts families across Kansas, the imposition of fines and fees. And so I thought a lot about today and what I would say during my 2 to 3 minute remark. And as I was working through a truncated version of the written testimony that you all have in front of you, I simply decided that I would spend less time reiterating the same stats and facts and quotes and more time telling you all the truth. And the truth is, much of what you've heard today has to be repeated so that we can get the message across that today we have a system that penalizes the youth and continues to create a system of poverty and further entrenches Kansas youth into inequities and a system that keeps them trapped. Furthermore, such fines and fees blocks the Kansas juvenile justice system from living up to its code and promise of providing public safety, ensuring accountability, and creating conditions for youth to go on and live meaningful and respectable and productive lives. As you've heard here, these types of fines and fees do not deter crime. Instead, the inequities within the system continues to harm families. This isn't unique to Kansas, as others have stated today, and there are a diverse coalition of groups working across this nation to recorrect and right this wrong, including in states like Texas. And what you have in front of you today is a varied coalition, and it's not just advocates or impacted families, but those who are working within the system. As you'll note, you have written testimonies from district attorneys who are also in support of this bill. So as you consider SB 416, I ask that you view this not just as an end to financial penalties, but as a way that Kansas can also course correct and allow for the juvenile justice system to live up to its promise. Thank you.
Thank you. Appreciate that. Thanks for being here today. Are there any other conferees wishing to testify as proponents on the bill? I'm not seeing any, so we will open it up for questions. Committee, any questions? Senator Haley.
Thank you, Madam Chair, and I appreciate each of the conferees that came forward. I'm going to be devil's advocate. Obviously, I'm supportive of what is a crippling measure for many of our youth. I want to thank the proponents that brought the measure because it just makes sense. I guess the counter argument and the concern is, and I will partially answer it, much of the government relies on these fines and fees to be supportive. When we shift, as we should, from children who are living with a lifetime of these fines and fees, as each of the proponents have, where do we absorb some of the costs of the system, if anyone would, the system that's going to be there, or how do we shift that? There was recently a discussion about the responsibility in a tragic measure where the parent was made responsible for the killing of someone who they let have their gun. In other words, so do we shift? I guess I see Mr. Fonkert getting up to, how do we shift the responsibility, the financial responsibility to whom? To the parent or guardian or to some other aspect of society? Because I concur, as I hope this committee will, we shouldn't have it, we shouldn't have these monies on children for the balance of their lives.
Mr. Fonkert, go ahead, please introduce yourself.
Thank you. Yeah, Mike Fonkert, Deputy Director, Kansas Appleseed. Thank you, Chair, and thank you, Senator, for the question. I think this coalition is not one that is going to propose that we shift the burden to parents. I think oftentimes when we're dealing with low-income families, that can add stress to already tenuous situations. But Kansas is a model in that we have the evidence-based program account, the reinvestment account, as many people call it, with regards to youth justice funding. And I think that's a perfect place for us to look at allocating some of these funds in an evidence-based way to replace the lost costs that are being collected. And you'll note the fiscal note last year that was produced on the House side shows that the amount of fines and fees being imposed has declined over time. And so I think this is a very reasonable use of some of those program account funds to supplement whatever costs are lost.
Let me follow up. What program account are you talking about?
The evidence-based programs account, it's colloquially known as the reinvestment fund that came after Senate Bill 367 in 2016. To my knowledge, there are still many millions of dollars in that fund that will be eventually expended for evidence-based programs.
Treatment programs.
And this is certainly an evidence-based practice to eliminate these fines and fees.
Thank you. Committee, other questions? I have a couple of questions maybe for Noah Bain with the Justice Action Network. I'm not sure. But as I was looking through the bill, it's rather lengthy. It's 45 pages. And I had some questions. So I was first told that this bill would only apply to not very severe crimes. But the bill in new section 1 at line 3 or 13, I'm sorry, says in any action. So am I correct? This would eliminate fines and fees for all crimes that are brought to court under the Juvenile Justice Code?
Thank you, Chair Warren. Yes, that is correct under the current base bill. The coalition has understood that concern and has had discussions about ways this committee could make amendments to address your concern with regard to the most serious crimes.
And also the bill at line 17 on page 1 and 18 through 26, any current outstanding court-ordered fines, fees, costs, court expenses, reimbursements, or other financial obligations owed by a juvenile or their parent, guardian, or custodian would be eliminated, right? They'd be discharged as soon as this bill became law, correct?
That's correct.
And then I have other questions about, I also thought that the bill was rather narrow in scope and purpose until I read it. And I thought when I mean narrow, I mean, okay, the fees and costs and the court expenses to be in court while you're having your case adjudicated or while you're being sentenced. And then maybe some fines because, okay, you shoplifted and that's a $500 fine. But the bill, in fact, is much broader. And I'm going to go over a couple of those things with you because my concern is, though we heard about the reinvestment fund, it would then put the burden on the taxpayer to be funding these things in the system. And that would be intervention programs, that would be probation, that would be a juvenile detention facility or a juvenile correctional facility or other supervision. And specifically, for instance, fingerprinting, we've heard our municipal courts earlier and other bills say that it's expensive to fingerprint and that shall not be imposed. The county law libraries, they get a fee with the filing of some of these juvenile justice actions. So the county library fee would be impacted, as well as house arrest programs that the juvenile offender might be ordered to participate in, including supervision costs associated with the house arrest program. And I'm not sure how expensive any of these are, but it would also prohibit the court from ordering the parent or legal custodian from continuing to pay child support for the child while the child is in not in the parent's or custodian's custody. So it's very broad in scope, and that just, on a first reading of it, causes me concern that, to me, a parent, continues to have a financial obligation for their child. I think for our Kansas Bureau of Investigation, this impacts them as well. The Sedgwick County Regional Forensic Science Center, the Johnson County Sheriff's Laboratory, the Heart of America Regional Computer Forensics Laboratory, the Wichita Sedgwick County Computer Forensics Crime Unit, the Garden City Police Department Computer Audio and Video Forensics Laboratory, that sometimes these are used, it says in statute, if that's needed for an examination under chapter 21, 41, or 65, as well as our juvenile justice code. So I guess my question and my point is that the bill, which I thought when I was first hearing it is very narrow, but it's quite broad as a matter of fact. And you don't have to pay back for the attorney appointed to you, which may currently be assessed, and now it shall be paid from the county's general fund. If you file for an expungement, that fee will no longer be the juvenile's responsibility. The docket fee won't. So I'm sorry, I'm just scrolling through the bill and I'm only at page 16 of the 45-page bill. And here, yeah, expenses for the care and custody of the juvenile shall be paid out of the general fund of the county in which the proceedings are initiated, and shall not be reimbursed by the parent, and the county may no longer bring a separate action to get reimbursed for those expenses. So just kind of playing devil's advocate here and looking at how this would impact when you're involved in an offense involving a sexual act or the transmission of body fluids or infectious disease testing and counseling. Those are no longer to be borne by the juvenile or the juvenile's parents, or counseling or testing fees. So again, it's quite broad in scope. So Noah, I didn't know if you had a reply other than, maybe this will be paid out of the reinvestment fund, but just kind of concerning that it's rather broad in scope.
Thank you, Chair Warren. And these are important questions, and I appreciate the opportunity to address them. I think that you are correct that the Kansas Code includes an enormous number of statutorily authorized, and in many cases required, fees imposed on young people through the juvenile justice system. That is undoubtedly correct, and the bill goes through to strike those. However, it is important to look also at what is actually happening in terms of the fiscal situation and on the ground in Kansas. And that information is found in your fiscal note. The fiscal note for this bill makes very clear that the bill will have a negligible, in other words, zero effect on the courts. That is what the Office of Judicial Administration reported to the Office of Budget. And the State General Fund has collected only an average of just north of $600,000 each fiscal year over the last 4 years, averaged together. You can see each fiscal year in that fiscal note. And so I would say that you are, of course, correct that those fees are being removed from the statute, but the actual impact is an average of just north of $600,000. Again, the total that Kansas taxpayers spent on juvenile justice as funneled through KDOC Juvenile Services last fiscal year was north of $500 million. $500 million. And so the fact of those numbers is simply that all of those, these fees are not being collected. They're not successfully serving as a source for the important work that juvenile justice stakeholders do every day to make sure the system functions.
So I understand that the impact to the court might be, I think you had said, a couple $100,000, but I listed quite a number of other entities that aren't court paid for by the courts. I've talked about house arrest. I've talked about the KBI, other forensics lab, testing, house arrest, and the bill would strike even the opportunity to petition, make a request that parents be ordered to pay child support in the event the juvenile is removed from the home. So, and those funds I don't think would go through the court. So this has, I think we heard some Department of Corrections impact as well. So I understand the impact on the court. Immediate intervention program shall not be paid for by the juvenile or the juvenile's parents. So then is it, ultimately to the taxpayer to pay for these services, or where does it get paid for other than from this fund? And again, I think it's rather broad reaching, but just my comments and thoughts.
I just want to clarify my remarks there. I'm just reading from the fiscal here to clarify for the committee that the Office of Judicial Administration indicates that the bill would have a negligible effect on expenditures and revenues for the entire judicial branch. The figures of 600,000 on average that I was referencing are what the fiscal indicates are assessed via various state funds and the state general fund. In other words, the total amount of juvenile fees assessed in FY 2016 to FY 23 are what the fiscal indicates, and it is a very tiny amount of money relative to what Kansas actually spends to function its system. Again, just north of $600,000 relative to $500 million spent last year on the system operations itself.
Committee, are there other questions? Senator Gossage.
Thank you very much for being here. I'm I'm noticing in some of the other information that I'm reading that there are other opportunities that are in place that do allow for fines and fees to be waived, and they are utilized frequently. Could you address that?
I think that's a question for Mr. Bain.
I'm sorry, yes.
Go ahead, Mr. Bain.
Thank you, Senator. Could you just clarify for my purposes which fees are utilized frequently and where you have information that those are utilized frequently? Because again, the total number assessed last year, according to the fiscal note, was just a few $100,000.
What I'm referring to is a conferee's testimony that's coming up. And we frequently do this because we don't circle back to you to give you an opportunity to address what a conferee that's coming up should say. So I was giving you an opportunity to address the fact that it says that that currently these fees may be waived and are utilized frequently. In some areas, it's more common. Court fees and fines are waived and assessed to a juvenile. Are you aware of that?
Yes, Senator. And again, the fiscal note indicates the real data in Kansas, which you are not looking at more than, I think the highest figure is $900,000 over the last 4 fiscal years in terms of what was assessed, not collected, simply assessed. And so when you hear about fees that were assessed, the Office of Budget is telling the committee that that is the figure that was assessed last year. I think that is kind of the underlying data. I would just, from our perspective at JAN, we always try to provide information in other states. And so in states like Texas or Arizona or Louisiana, those fees that you are discussing as obviously going to a very important system operations, those fees are paid through other means outside of fees. They're no longer paid through fees imposed in the juvenile justice system.
And one last question, if I may, Madam Chair. So we've seen that the legislation determines that a parent or guardian cannot be detained for the sole reason for fines and fees, right? So we're not detaining the juvenile because of fines or fees. Just want to, again, give you an opportunity to address this. Because I agree, it seems very broad. Initially, when I was reading through it, it seemed like it was going to be for some of this, I guess I'll, for lack of a better word, say simpler or lighter sentencing or crime. And it seems like we're basically saying for all crime. So again, just one last opportunity for you to address that.
Thank you, Senator. And I'd open this up to any other folks in the room, but I would just say from my perspective that it is the case that folks would not be incarcerated. That is only solely because of unpaid fine or fee. So again, if there's any other reason, there is an opportunity to incarcerate, but that would be basically outlawing debtor's prison in the juvenile justice system when someone would be incarcerated solely for a fine or fee. And that's really just bringing Kansas up to speed with state practices across the country. I would be surprised if that is a common practice in Kansas, incarcerating someone solely because of a fine or fee, especially given Kansas' enormous success in focusing on community-based interventions and reducing recidivism through those means in recent years.
Thank you. Thank you, Madam Chair.
Thank you. I have a question for you, Mr. Bain. On page 26 of the bill, it talks about an evaluation and written report by a mental health or a qualified professional stating the psychological or emotional development or needs of the juvenile. The court may order that report from any mental health or qualified professional who has previously evaluated the juvenile. And then if the court orders an evaluation as provided, the parent shall have the right to obtain an independent evaluation. And currently, the law says at the expense of the parent. And with this bill, it would be to no cost to the parent. So you're going to, I guess, go get a private, another evaluation that's going to be borne by the taxpayer, which currently is being borne by the parent of the juvenile requesting the second evaluation. Expenses and fees for post-adjudication tools currently can be waived, but under the bill shall no longer be assessed. And again, that's probably for probation and other activities. Community-based programs there shall be no financial terms or conditions placed on the juvenile or the juvenile's parent, guardian, or custodian. And again, if the juvenile is placed in the custody of a parent or other suitable person, requirements pertaining to child support no longer apply under this bill. And again, that's only on page 28 of the bill as I'm scrolling through. When the child is placed in the custody of the Secretary of Corrections, requirements pertaining to child support shall no longer apply under the bill. And so again, if you're ordered to complete a drug and alcohol evaluation by a community-based drug and alcohol safety action program, that shall no longer be the juvenile or the parent's responsibility. And currently, for low income or indigent, the court may waive the fee, but with the bill, it's simply struck, including for ongoing required drug or alcohol testing. So, again, those aren't entities that are, well, they are who they are. So I'm just, again, continuing to look through the bill and finding that this is rather broad reaching. And so just some additional comments. Committee, other questions? Senator Haley.
Not so much a question, but along the line of your inquiry, Madam Chair, I don't know where the drafting came or if this was from model legislation from somewhere else, but I hope that we will be focused on, I think, what the kernel or the peanut or the gist of what the underlying bill has, and to which our proponent conferees have spoken to, and that would be the core costs of the implementation or concerns that are lingering on children, on the juvenile, well beyond that. And so, if there is going to be some further question, as you have so aptly raised, and I certainly tend to concur that we might look to how we redraft or look at amendments that would take certainly post-adjudication costs, especially supplemental costs that are determinative of what they opt to do, certainly child support, some of those measures, and we don't lose sight of what the primary point of this bill is, and that is to take those costs off of juveniles that linger beyond that. So I say all that preparatory to, I think we have an opponent who's coming up to speak, because I tend to share your concerns as well, and hope we'll look toward drafting what would be a suitable amendment for the committee to consider, and not throw the baby out with the bathwater. That's not a...
Thank you. Committee, other questions? Not seeing any. Then committee, I will direct your attention to your committee folder. There are other documents in there from Tanya Avery, youth leader, intern of Progeny; Adonijah Metcalf, youth leader, intern of Progeny; Mark A. Dupree Sr., Wyandotte County District Attorney; Suzanne Valdez, Douglas County District Attorney; Sarah Johnson, Senior Youth Defense Counsel, the Galt Center; and Ebony Stoutmiles, State Policy Advocate, Juvenile Law Center. And with that, then, there is also neutral written-only testimony in your committee documents. Laura Blake Boers, Juvenile Justice Oversight Committee. Do we have any neutral conferees wishing to testify today? Not seeing any, then we will invite opponent conferee Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. I am Jay Hall, the Deputy Director and General Counsel for the Kansas Association of Counties. You have my written testimony, so I won't recite that, but I do want to make a couple of high-level points on that before I stand for questions. And the first is that this is a complex issue, and I want to make sure that we are looking at the issue. And one of the things that this bill does, and I think Senator Warner has already addressed some of these concerns, is that it is a very broad bill in that it just carte blanche eliminates all fees without any sort of consideration of what those fees do or the purpose of those fees. And so that is one of the concerns that we have, and you'll see in my testimony that I actually recommend that we utilize the Judicial Council to study this issue so that we can determine what, if any, fees should be eliminated, if there are fees that maybe should be lowered or things that should be adjusted based on income or needs-based assessments. Those are things that should be considered when we consider eliminating all of these fees or looking at these fees, because I do think there is probably some room to look at these fees, but I think it is an issue that deserves more study rather than just carte blanche eliminating all of the fees and then looking back maybe 5 years from now and saying, oh, we actually probably shouldn't have eliminated this fee or that fee, rather taking a proactive approach and looking at the fees and determining which ones maybe should be eliminated or adjusted, or giving additional discretion to the courts to assess those needs at the case-by-case level. With that, I'd be happy to stand for questions.
Thank you. Committee questions. Any questions? Senator Haley.
Let me yield to Senator Corson to our ranking if I could. I saw he would, because mine will be a follow-up, if that's all right.
Sure. I was just talking with him about that. Senator Corson.
Thank you, Madam Chair. My question is kind of like, I'm trying to tease out exactly why the Kansas Association of Counties is here and why they have an interest in this kind of juvenile justice reform legislation, because I feel like I'm reading through the lines and I'm trying to understand. It feels like one of the reasons you're here is that you're worried that if we pass this, that you'll collect less money in fines and fees, and then counties would then have to backfill some of what was previously revenue. Is that why you're here? Because you don't have any expertise in the policy matter.
Right.
And so that kind of your concern?
We have a concern that there may be some backfilling, because as you see in the bill, it's noted in several places that the county general fund would take over for funding some of those things. And so that is our concern. And we are prepared to do that if it is determined that those fines and fees should be eliminated. But at the same time, we want to make sure that we look at this issue and make sure that the experts and all of the stakeholders have weighed in on those fines and fees to determine what is necessary and what maybe should be waived or eliminated.
Okay, because I would say I think we have, as a legislature, looked at this, because I know that I've been on the Joint Committee on Corrections and Juvenile Justice for the past 3 years. We've looked at this each of the past 3 years. These are recommendations that have been made unanimously by the committee every single year after receiving extensive testimony on this issue. So if the county's only thing is they're just worried that they're going to have to backfill the money, I don't feel like that's a real solid reason to oppose what I think are otherwise really thoughtful reforms that have been taking place, as was mentioned, by a broad coalition of folks over a number of years. So I was just trying to tease out kind of why you're here, and it seems like it's just money related. So thank you.
And want to make clear that anyone is welcome to come testify in our Senate Judiciary Committee. So thank you for being here, sir. Committee, other questions? Senator Gossage.
To follow up what Senator Corson had said, I point to the testimony from the Juvenile Justice Oversight Committee, and it does state that it is overly broad and in practice, and that there are opportunities to waive fines and fees currently. And so I wondered if anybody in the room could address that, or if the individual who brought this to us could address that. I know it's written only.
Well, we're at opponent testimony at this point in our committee, but thank you for the question. It's not our usual practice to go back to proponents, so we'll go ahead and stick with that. And I'm just thinking.
Madam Chair, this is neutral.
Okay, I'm sorry. Neutral written only. Okay, we have neutral written only from the Juvenile Justice Oversight Committee, so not proponent, but neutral only. Okay, thank you. And that is written only. And currently, our court system, they wouldn't be impacted by the taking away of fines and fees either, because the courts are currently funded through state general funds. So they're funded by the state, which is the taxpayer, and then would be funding the courts if they were no longer collecting docket fees or court expenses or court costs or things of that nature. So are there other questions from Mr. Hall?
Madam Chair, I would
Yes.
note as well that obviously the taxpayer would fund it at the county level as well, through property tax payments. So it's still taxpayer dollars, whether it's funded at the state level or at the county level.
True. Thank you. Committee, other questions? Yes, Senator Gossage.
Just one last comment, if I may. I would like to echo what Senator Haley said, which is that obviously reform needs to be made. We just want to make sure that we're doing it in a measurable manner, and that we're not taking away fines or fees or deterring actions that maybe a fine or a fee might encourage someone to do the right thing or not be a new offender, if you will. And I don't have those answers, but it looks like that there is more discussion to be had. Thank you, Madam Chair.
And I would just note that I struggled with whether I wanted to be an opponent on this. I determined ultimately that I would be an opponent because I'm not sure that eliminating all fees is the appropriate step, but I am open to the discussion of eliminating or changing the way we assess some of those fees.
Thank you. With that, then, if there are no other questions, thank you for being here and for your testimony. Appreciate it. Are there any other conferees wishing to testify as opponent? Not seeing any, then we will close the hearing on Senate Bill 416. And we are at 11:30. We are on the Yes, thank you, Senator Corson. He reminded me of the minutes, which I almost decided to do first, but leaving them to last, we can now take a look at those as well. So committee, at your desks today, you do have proposed meeting minute drafts from March 5th, March 6th, and March 7th. And we'll take a moment to have you look at those, and then we will, when anyone is ready for discussion or a motion, we will entertain that as well. Yes, Senator Gossage.
Thank you, Madam Chair. I move that we approve the minutes as submitted.
Second.
Thank you, Senator Gossage, and thank you, Senator Olson, for the second. Committee, any discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Now, committee, we are at a little bit after 11:30. We do have the opportunity to work until noon. However, our floor activity has been moved up from our regular session of 2:30 till 1 p.m., which also means that our 1:30 committees, many of them have been moved up to the noon hour. So including one that I'm on. So with that, then we want to give our senators an opportunity to make sure they get to their noon committees if they have one. Thank everyone for their work today, staff, committee members, those conferees, and those following along in the committee meeting room and online. And with that,